So how do you make a change to your will? I'm Michael Redden, and today we're going to be talking about this topic. If you have any questions or concerns, please leave them down in the comments below. You know, a lot of us got a will done, might be 5 years ago, 10 years ago, even just last year. And things have happened in life, and we want to make a change to it. It may be a minor change, like a name switched out or something like that. Or maybe you just want to change the percentages you give to people or a number. Now, some of you might think that you can then just take out a pen, make the change, have it notarized, or just initial it and it's good to go. Unfortunately, that's just not the case. See, we have to have that original will, and any of these alterations to it are going to be disregarded or make folks think that maybe this isn't the original will. The proper way to make a change to a will is either to make a new will and revoke the old one, or by a special document called a codicil. A codicil is just this little document that has the change in there, but here's the key to it, okay? It's written in a way that people recognize what it's for. It doesn't make unnecessary changes to your will. It doesn't make the court think maybe you tried to revoke the will or parts of it or things like that. And it has those same two witnesses. When we come to things that have to do with our will, any change we make has to be done in the same way that we made our original will. So you got to have those two witnesses, and those two witnesses have to sign it and have all of their signatures notarized. That's really the key to making a proper change to your will. Minnesota doesn't recognize handwritten wills. So if you make a handwritten change in Minnesota or in any other state that doesn't recognize them, they're not even going to recognize that handwritten change to begin with. And you've brought these other problems up about, do we doubt your will now? Do we doubt that the will is still your wishes? Has it been revoked? We don't really want to bring those kinds of questions up. So you could potentially do it yourself if you write a codicil the right way and have it witnesses there and get everything notarized. But even more than when you made your will originally, you want to have an attorney involved for that kind of codicil or change. Even if you downloaded these documents and got them from LegalZoom and did those kinds of things, you need to have a codicil to make a change. And codicils don't do very well when it comes to having those downloadable documents. I mean, there's all different kinds of changes you can make. You can't really anticipate and have this set form where you just check the boxes and things like LegalZoom does. So along with any of those other kinds of things, LegalZoom or someone's going to want you to make a complete change in a new will. If you're already making changes to it and thinking about those things, you probably need an attorney's advice, probably need some discussion about it. And it is cheaper to do a codicil than to completely redo a will. Just make sure you do it correctly. I'd hate for you to make those changes and cause your entire will to be brought into question, so that those handwritten changes made it so they treat you like you didn't even have a will. So remember, if you want to make a change, get a codicil. It's got to have those two witnesses signatures on there. Handwritten changes just won't work, and they might cause the will to come into question. If you have any questions or concerns about this, please put them in the comments below, and I'll be glad to answer them for you.